All right, so I want to thank everybody for attending. Um, Before I introduce our very well-known speaker, I mean, look, Adam is kind of famous actually. But let me just repeat what our mission is here. So, um, the mission of U.S. Inventor is to restore to inventors and patent-based startups the ability to stop an infringer from simply taking whatever you've invented without your consent. You should have, as our Constitution says, you have the exclusive right to your invention, no matter how powerful the infringer, no matter how politically connected they are. You should be able to stop them. And if you want to sell to them, fine. If you want to license to them, fine. But it should be an arm's length transaction. And if you want to just hold it to yourself and have a startup that competes with them, they should not be able to take it away from you. They should have to out innovate you. And that's what has made America so innovative and has put us ahead of all of our adversaries. It's this incentive to innovate that our fabulous patent system created that we've unfortunately lost in recent years. So that's our mission, and we're working on many fronts, as you know. We'll probably have a little bit of a discussion at the end about what we're doing, but I want to introduce our speaker. So Adam Mossoff. Adam Mossoff has been speaking and writing, and he's been in numerous hearings on the issue of patent rights and property rights. He's a professor at what's the school?
Antonin Scalia Law School at George Mason University. It's a mouthful.
Yeah. And Adam has been involved in our area for certainly over a decade, maybe a couple of decades. I mean, he's among the people who have been fighting for inventors' rights. You know Adam Mossoff. You've seen his writings. You've seen him in hearings. I remember it may even come up a particular hearing I recall where unfortunately one of our enemies kind of tried to ignore you. But of course, you know, our enemies will try to ignore the truth. And but anyway, with no further ado, I want to introduce Adam Mossoff.
Well, thank you, Randy, and and everyone at U.S. Inventor, Paul and Josh, and all of the members. It's a really important organization that certainly fulfilled a deep need, a necessary need to advocate on behalf of inventors and the innovators who have driven the U.S. innovation economy for over 200 years. So it's a real pleasure and it's a real honor to have been asked to speak to you at this meeting. Personally, I've long been admirer of innovation and of inventors who drive innovation, who create using their mind and their energy and their productive labors to create the new things that have made modern life, in the 21st century, a veritable miracle by any historical standard. And something that I focus on, as Randy mentioned, is a lot about the importance of innovation and the importance of how the United States has secured what I refer to as reliable and effective property rights, patents, in innovation, how that has been a fundamental pillar of what has made the American experiment that began in 1776 so successful since that time, and especially since 1787, when the founders put the patents and copyrights into the Constitution, authorized Congress to secure them because they recognized the important role of innovators and creators, especially for what was then our startup country. And that the need in that what would make our country grow would be the innovators who created the startup companies and businesses with their innovations that drove the Industrial Revolution, and then eventually the technological revolutions of the 20th century, and then our continuing revolutions into the 21st century. So what I'm going to do is just speak for about 10 minutes maybe, because I really want to get into a discussion with all of you. I want to hear your questions. I want to have kind of a back and forth exchange. That's one of the things I really enjoy doing. But I thought what I would do is kind of share with you some of my research and some of my insights that I've developed over the years. All of you are doing the important work, the brass tack work of innovation. And so, it's people like me who work as scholars and as researchers and as policy advocates to kind of, spend our time, digging deeply into the historical record and into the various life experiences and work experiences of great innovators like Samuel Morse, the inventor of the telegraph, and and Thomas Edison. So many inventions that are the hallmark of modern American society. So I'll share with you some of my work that I've done, and then happy to answer questions about that work and about any broader issues that are of importance to you that I might be able to weigh in on. So as I kind of referenced already, historians and scholars sometimes refer to what is America as by the phrase American exceptionalism. And that phrase kind of captures, in a very kind of succinct way, in a rhetorically compelling way too, the unique combination in the United States of limited government, rule of law, the protection of individual rights, the core rights of life, liberty, and property, and the American cultural attitude about life, that kind of pragmatic, hands-on, very active, engaged. We can, fix any problem, build any machine that will make life better. It's this, this kind of unique, kind of classic American sense of life, that we can flourish and succeed through our own productive activities as long as we're left free by the government and protected by set rules, and equally between all of us. And what a lot of people don't realize is that the patent system is very much part of American exceptionalism. Something that, of course, U.S. Inventor highlights and many others do. The founders, authorized in the U.S. Constitution. This was the very first time in human history that this had ever been done, that a founding document of a country mentions explicitly patents and copyrights as one of the responsibilities of the government to protect. And Congress immediately acted on that authorization. And in fact, something I often have pointed out in my various times I've testified and in another context, that in fact the word right, as in an individual right, you only find it in one place in the original Constitution of 1787, before the Bill of Rights was adopted and enacted by the Congress in 1790, and that is in what we now refer to as the Patent and Copyright Clause in Article 1, Section 8, Clause 8, where Congress is authorized to secure the exclusive right to inventors and authors their respective discoveries and writings. And the founders understood what that meant, that this wasn't a special privilege grant. This wasn't something that was being done for purposes of mere economic policy, or this wasn't just a mere socially conventional understanding that we might want to do this. They understood that this was fundamental to what it meant to have not just a successful economy, but a just social order. That it was part and parcel when you secure people's rights to life, liberty, and property. Property doesn't just mean the farm and the house and the carriage and the horse at that time. It meant the innovations that went into making the farm possible. The invention of the hoe and the invention of the reaper and the invention of the harness and the invention of and all the other tools and mechanisms and practices that make up actually what all the values we use in our life. And the founders understood that. And it's why they put it into the Constitution. And in fact, it's why Congress, in its very first year in sitting in Washington, D.C. in 1790, it's referred to as the first Congress, they immediately enacted the Patent Act of 1790 and the Copyright Act of 1790 under their authorization under the Constitution. I mean, and to put this in context, this was a time when Congress spent weeks debating about how they were going to refer to President Washington. Were they going to refer to him as His Excellency? Were they going to refer to him as His Highness, Mr. President, His Honorable President? They spent weeks debating this, what was going to be the appropriate salutation for the president. But there was no debate over the Patent Act. It was enacted immediately and was implemented very quickly. And the very first patent issued and signed by President Washington in 1791 is a patent that issued to Samuel Hopkins for a process of making potash. And then the next several patents issued to another inventor, a serial inventor who received several patents. So he's also the first person who received multiple patents. His name was Oliver Evans. And both Hopkins and Evans are classic exemplars of American innovators. They were not they didn't have specialized training. They didn't come from aristocracy. They weren't wealthy to begin with. They were upstarts. They were pulling themselves up by their bootstraps, inventors who kind of working in the 18th century equivalent of their garages created their inventions and then secured them with the property rights through the U.S. patent system. And in fact, Oliver Evans has the distinction of being actually the first very successful licensor of patents. So Hopkins also licenses patents. People don't realize this, that the first patent, recipients of patents in this country were not manufacturers. So they embrace the division of labor that has driven our advanced economy, a capitalist economy, and they license their property rights, their technologies to manufacturers and to retailers. And Oliver Evans, in fact, not just has the distinction of being the recipient of multiple patents, he has the distinction of having received a entering into a license with President Washington in 1791, which shows you how deeply ingrained an idea of the importance of patents and the respect for patents as fundamental property rights was. President Washington in 1791, if he wanted to just take Oliver Evans' technology, I mean, he could have. Oliver Evans could have sued him, but I mean, he would have been excoriated in the newspapers for suing and attacking our president. I mean, President Washington could do no wrong at that time, right? And yet President Washington recognized not just the legal requirement, but the moral importance of paying someone for the use of their property. And it was and what he received a license for from Oliver Evans was a method of operating his mill at Mount Vernon. The mill is still there. In fact, they don't mention Oliver Evans' patent, but if you visit that mill, know that is the site of one of the very first licensed patents in this country for manufacturing purposes, and it was licensed by President Washington from one of the earliest U.S. innovators. And this is the story of U.S. innovators from then on for the next 250 years. Whether you're talking about Samuel Morse, who was a professor of art at NYU and New York University in the 1830s when he invents the electromagnetic telegraph and Morse code, whether you're talking about Elias Howe, the inventor of the lock stitch, a fundamental component of what makes the sewing machine practical, usable technology. He no formal training in mechanics, no schooling at all, in fact, and he came up with this key technology that people have been trying to figure out for over 100 years, all the way up through Thomas Edison, who came to represent everything about this country in terms of what you make possible by securing to inventors the fruits of their productive labors and protecting them under the rule of law through the courts and through settled doctrines, like you do with all other property rights. And so in the same way that farmers are protected in the fruits of their labors, spending a year planting the crops, watering them, husbanding the crops, keeping pests, keeping the pests away and things of the sort, and invests an entire year of their life, sunk costs, before they can reap their crops and then sell them to the jobber, to the person who then takes them to market. That same idea was recognized as applying to inventors. That the inventor spends the time of their life coming up with this new invention, this new innovation. It's a productive labor, and they should be secured in the fruits of it. In fact, the courts drew this connection between securing the fruits of labors and farmers and securing the fruits and labors of inventors very early on in this country in the 19th century, as I found in my historical research. And so, what you are doing today is part of this fundamental tradition that has meant so much to not just everyone who lives today benefits from your activities at every level. But what you are actually representatives of is American exceptionalism. You are the exemplars as innovators and inventors of what it means to be an American and what America has meant to the world. So with that, I'm going to close my opening remarks and thank you for that, and take questions.
I have one I want to start with, and that is
Yeah.
certainly our founders were brilliant individuals, and
Mhm.
they were on the right track here. But I wonder if they realized how how patent rights were going to change the world. And I wonder if there were writings that where George Washington or others had some indication of how big this was going to be.
Yeah, no one really foresaw the Industrial Revolution, and for the same reasons that very few people foresaw the biomedical revolution of the early 20th century, and then the high-tech revolution of the late 20th century. No one foresaw the amazing revolution that Josh Malone brought to us with his bunch of balloons and incredible happiness. That I was so excited when I met Josh, because I had benefited and enjoyed the products of his labors for so many years with my children. So no one foresaw like that, the radical alteration in human society that was wrought in the 19th century by the unleashing of freedom, the protection of property rights, and in particular the protection of new inventions and innovations that drove the Industrial Revolution from steam engine, Watt's invention, the steam engine, to railway car, to railroads, as I mentioned, the telegraph, and even Samuel Colt's repeating firearm. And the mechanized reaper, Cyrus McCormick, and Singer and Elias Howe with the sewing machine, and so on. But they did have a sense of that something like that could happen. In fact, George Washington isn't just the father of our country, our first president, one of the very first public officials to license a patent. He was also an early version of what we would now call a venture capitalist. So he actually was investing and funding various inventors in Virginia who were experimenting with steam engines at that time. And in fact, the founders, this is not well known as much. So at the Constitutional Convention of 1787 in Philadelphia, where the framers of the Constitution came together to write the Constitution over the course of a very hot summer, Robert Fitch went to Philadelphia. Robert Fitch was one of the early innovators in steamboat technology, and took the framers to the river, blanking on the name of the river in Philadelphia at the moment, I apologize, and demonstrated them his steamboat as an example of the types of technology that were being innovated at that time, and the importance of protecting them. And Webster, of Webster's dictionary, the first American dictionary, famously also went to the Constitutional Convention and explained to the framers that he needed protection throughout the entire country for, in other words, he needed copyright protection for his books and his creative labors. And so they heard directly from inventors and creators at the convention that if we are going to succeed as a country, if we are going to have the creation of steamboats and in dictionaries and other types of creative works, you need to protect us in the same way that if you're going to have new manufacturers and new farms and new homes, you need to protect the property rights in those activities as well.
Thank you.
So there's a question out here that is asking what you think of Massey's HR 5874.
Oh, what do I think of it? It's a great bill. It's it's what we would say in academia. It's wonderfully aspirational. It would return in terms of being. It represents the ideal of kind of what we would all aspire to. Returns our patent system back to the patent system that we had before it began to become radically altered by the Supreme Court, by Congress, by regulatory agencies, starting about 20 years ago. And so eliminates the PTAB. It reaffirms that patents are in fact property rights. It it reverses many bad decisions by the U.S. Supreme Court that have misconstrued and misapplied the statutes that Congress has enacted, and it would do much to restore kind of what I refer to in my writings and my work as kind of the reliable and effective protection of property rights, in the same way that you have reliable and effective protection in your home. So if someone breaks into your home, you can call the police, and if they damage your property and breaking into your home, you can sue them, and you'll win. And that same type of kind of consistent protection and reliance needs to be reestablished again for patent owners, for innovators such as yourselves.
By the way, I want to say one thing on that, because I know you said it's aspirational. So it's pretty there's a feeling in Washington, D.C. by some that it's an effort to do too much. But I got to tell you, the ground really has shifted because of the situation with big tech taking over everything, and with China becoming more and more of a threat in technologies. We've had a pretty massive shift in the ground that I think makes this bill passable if we really do our work. So not this Congress, but in the future.
Well, I think that's exactly right. I mean, at a minimum, having bills like Representative Massey's bill are really important, because it sets the framework for having the appropriate policy discussion. All of you don't enter into a commercial negotiation asking what you want to end up with at the end, because if you ask for that, if you ask where you expect to be after you compromise and negotiate, you start from there, you're going to end up in a worse place. So you start by asking what you really want. And so that's the real significance and importance of that bill, is that it kind of establishes that framework, that this is the range of the policy discussion that we're supposed to be having right now. It's not this little narrow sliver, are we going to tweak a couple rules here and there and, polish the USPTO so it's a little shinier? No, are we going to fundamentally alter that institution? We're going to fundamentally reverse some of the bad decisions by the Supreme Court and repeal some of the bad laws enacted by Congress. And today's crazy ideas, tomorrow's real world policy proposal. We see this constantly. And so, that's kind of a cliche, but so I don't mean that Massey's bill is crazy, but just that, people who think it's crazy, right? Because, they hadn't thought of this as being the appropriate range of the policy debate. And as it gains support and becomes more and more part of the regular policy debate, then it becomes something that people, Randy, I think as you rightly say, start to say, well, maybe that is not such a bad idea. Maybe it's not so crazy. Maybe it is something that we could actually potentially do. Yeah. And that's how it works. And so, in the meantime, we can also, we should push for Massey's bill. And in the meantime, we should also push for, in the interim, also, smaller measures too, so that we can continue to move the ball forward. And the point is to create momentum, both in support of something like Massey's bill, but just shifting the narrative completely, as you mentioned, so there's been the black eye that big tech has taken in the past, 5 to 6 years. It has been really good, but that's a negative on big tech. You need now a positive on innovation and positive on the patent system. And so we need to work on that, both with something like Massey's bill, which is, as you said, not this term, but maybe in the next term of Congress or a future term of Congress as a long-term goal. And then we have shorter term goals as well, like I think like Representative Senator Tillis's 101 reform bill and things like that we can continue to work on as well.
Yeah,
Joel, please, yeah.
Yeah. So thank you, Professor Mossoff. I'm mainly a litigator of all kinds of IP infringement and cases, and including patent. Two questions, because I think your historical knowledge is particularly interesting. And I had recently a case where the other side was arguing issues about royalties, and I'd never thought the historical context or even where the term came from, and that it must have something to do with royalty, as in this was at one point prior to the U.S. and the Constitution, this was a grant from the Crown, you had an exclusivity. So I was very curious about that, just in general. The other issue was, was litigation ever meant to be so onerous? And was it that onerous in the early days of, of the Republic? And isn't it, from your perspective, is there anything that can be done to make it less onerous for inventors who are granted that monopoly and need to protect it to be able to defend it?
Yeah, so great questions, Joel. And I have to confess, I'm embarrassed. I don't know the etymology of royalty as a term for of payment on a license or on a contract. Your question actually has made me think I need to go find this out. So tonight I'm going to go look this up. And I'm very embarrassed because I've been writing on licensing and license practices for 2 decades now. Ron, I don't know if you know, I saw your Ron, who has actually received royalties and is engaged in licensing as well, if anyone else knows.
Yeah, thank you. I don't know the source of the word royalty.
Okay, but then
but I do recommend to people not to use royalties for patents, but in fact to have royalties or licenses for products that may be protected by patents, so they don't get subject to the eBay thing. So they have an actual product to sell.
Yeah. And then on Joel's other question about the onerousness of litigation. So America has always been a litigious society from the get-go. And if you read old newspapers and pamphlets, people have been always complaining from the 1880s or 1780s, 1790s, 1800s. There's, litigation's so expensive. We hate lawyers. Lawyers are horrible people. Let's kill all the lawyers. Beating up on lawyers is a great American tradition. And in fact, I identified some of this in some of my early published articles, such one of my famous articles on the sewing machine war of the 1850s, which was patent war over between all the different inventors who contributed to the sewing machine, between Elias Howe and Isaac Singer and others. And I talk about some of the details of the cases that I had found in the newspapers and reports of deposition records being thousands of pages long. And by the way, this is a time period where people are handwriting these documents, right? There's no typewriters, there's no computer. And people complain, and people complain about these cases going on for years and years and years. And this is a time when no telephones, travel by horseback, and other things of this sort. So litigation's always been a central aspect of American culture. And by the way, that's not a bad thing. It's actually part of American exceptionalism, because you as a country and as a government, you have two choices of how disputes are going to be resolved or addressed. You're either going to ascribe private rights to individuals in terms of, when I mean by prescribing the law, recognize their rights of life, liberty, and property. And then when they have a dispute over them, they get resolved through court, through a private lawsuit and private litigation with the judge operating on the rule of law. Or your alternative to this is regulation, where you have a government administrator decides kind of on high or beforehand, well, this is how I think society should be structured, or this is how I think your life should be run, or this is how I think you should be using your property, and this is how you're going to do it. And those are our two kind of choices, our two fundamental institutional choices we have, and how people are going to have, how they're going to resolve disputes in our country, and how they're going to decide the rules of how they're going to live their lives, especially between each other. And the United States took the approach very early on that, unlike in Europe, with very heavy administrative states created first by crowns and then later by the governments generally, like in Germany under Bismarck, we would take the approach that individuals would be left to their own devices, and if they have a conflict with another individual, they go to court. And so courts are very much part of that American feature of individualism and freedom, and letting people resolve issues between themselves instead of government agents and officials making decisions on behalf of people. And so this is why litigation's always been a central feature of American life. It's not bad because you have to resolve disputes are going to happen. You have to have a way to resolve them. And so this is why I don't think patent litigation is a necessarily bad thing. It's going to happen. It has to happen, especially when you have new inventions, because you have questions about what's the scope of the property right in this new thing? What is this new thing? What's the nature of the new business practices that people engage in and deploying in the marketplace, and so on. So there's historically always been complaints about litigation, about the expense of litigation, because it's always been such a central feature of American life. But it's gotten worse in the 20th century because of a lot of so-called reforms that were adopted in the 1960s, which created the discovery process that you all probably are very well aware of if you've ever had to sue on behalf of your property rights. And and so this made it much more burdensome and much more expensive. But this isn't unique to the patent system. This is a problem with all litigation. All civil litigation now in this country is extremely expensive and difficult because of all of these extra procedural hurdles and burdens and processes that have been imposed upon people through the courts, and that began in the 1950s and 60s and continues up to this day. So the complaints about the patent system and the patent litigation are not unique complaints about patents. They're in fact, this someone a decade ago when when we were debating the Innovation Act and all of these proposed changes to how patents would be litigated, a lot of us kept pointing out that these aren't complaints about patents. These are complaints about federal litigation in federal court generally. This isn't something that's unique to patents.
I have a follow-up question. This is Josh. Thanks. It's a privilege to be here. Thank you for joining us, Adam. And we got a great turnout this evening. I want to help get this in perspective because, as you know, I went through a very tortuous litigation process.
Yeah.
And best I can tell, these disputes take about 15 years to conclude. Mine was settled early after 4.5 years because the billion-dollar infringer ran out of resources and couldn't afford to go on. What's the right amount of due process? How long should it take to get to a trial? And what should the appellate process look like?
Yeah. Those are great questions. We talk about this in law school and we debate these issues in conferences. To be frank, I don't know what the right amount of due process is. If I did, I'd be philosopher king, and I would be solving all of our world's problems. It's a really difficult thing. These are really difficult foundational questions. And on these types of issues, I'm always my default rule. That's a legal term. I'm sorry, it's lawyer speak. My basic presumption, the way my starting point is that we should look to we should let people make the decisions about how to structure their activities and not look to government officials and agents to decide beforehand what it should be. Now, a lot of the expenses, Josh, that you identified, and Joel, some of the expenses that people incur today are not part of patent litigation, as patent litigation should occur. They're part of the PTAB process now, very much part of the PTAB process now. They're part of the massive slew of new defenses that infringers can invoke to try to invalidate a patent. The Alice Mayo test and the KSR test and all these new decisions in the U.S. Supreme Court that have put a thumb on the scale in favor of the infringer, who sued as a defendant, who can now impose all of these extra costs on the patent owner, who is now simply trying to say, you've taken my property and I should be paid for that. In the same way that if you broke into my house and walk out of my house with my beloved beagles, I should be compensated for that, or I should have my beagles returned to me. So that should be certainly eliminated. So and those expenses are completely unnecessary and are unjust and are improper. But it's difficult to say with any certainty, well, then how many years should it be, or what should the expense be? Because it would vary from invention to invention. It varies given the nature of our technology and our society and our capabilities of communication, and how well our institutions can function with computer technology versus not having computer technology and things of that sort that we can't predict.
So I've got a question from Matt that kind of goes back to history. Can you speak to Thomas Jefferson's initial position on patents, how and why it changed? Also, is there a record of George Washington influencing anyone to include patent protections during the Constitutional Convention?
So I'll answer the first question, the second question first, because that's the easier one. So George Washington didn't play a direct role at the Constitutional Convention with respect to the Patent and Copyright Clause. So what we know of the Patent Copyright Clause and its origins at the Constitutional Convention is entirely from James Madison's notes. He has the authoritative notes that he took at the convention. Is that the Patent and Copyright Clause was proposed, and he wrote in his notes, it was voted on unanimously without any debate. So that's the entirety of it's one side. And then it was sent to the Committee on Style, and the Committee on Style, which was the final committee that kind of drafted the Constitution, the language that we now have, wrote the clause as it is now. And there's some, and in the Committee on Style, we do have some knowledge of some competing language where the clause originally was broader than just patents and copyrights. It authorized the creation of a university. It authorized prizes and other types of things, which it's revealing that they chose not to adopt that, right? That they focused on just the issuance of patents and copyrights, again, going with this kind of what I refer to as bottom-up, right, system of property rights, where you're just like with the farmer, you're just saying, here's your property right in your farm. You see if you can make your farm valuable. You see if you can have fruits of your productive labor sufficient to sell in the market and support your family. It's not our job as the government to decide ahead of time whether we think your farm is going to be valuable or not. That's your job to figure that out and to make that happen. They took the same approach with patents as property rights. So no direct influence by Washington per se, although and there's very little writings actually on patents by the founders and framers, except for one person, Thomas Jefferson. He was an inventor himself. He invented for instance, one of the first duplicating machines. You can see it at Monticello, where it's an arm attached to a pen where he would have a second pen. So as he was writing his letters, he was making a copy of his letter as he was writing a letter, and many, many other inventions that he came up with. And of course, he was actually on the board, the original board of 3 government officials that reviewed patent applications and issued patents, given his interest in it. And but he's also known very famously for being a skeptic or a critic of the patent system. So he wrote this very famous letter to an inventor, Isaac McPherson, in 1811, where he bemoaned that these are monopolies and they should be reviewed very skeptically and suspiciously and be restricted, and that there's no natural right to them. And this letter is quoted often by the U.S. Supreme Court and by many people who try to weaken patents in our country, right? Trying to say, see, the founders were opposed to it. And that's one of the things that got me most interested in the history of these issues, is because I kept getting hit with that letter in my academic work and by other academics who were very skeptical of patents. And so I still remember, it was about 18 years ago, I just kind of, I sputtered at a conference. I was like, well, who cares what Thomas Jefferson thought? And so that what spurred me on to kind of read every patent decision in the 19th century. There's about 1,400 of them, and really immerse myself in the historical documents to find out, well, was Thomas Jefferson representative of the American approach to patents, or was he an outlier with that letter? And what I discovered was he was an outlier. And it led to one of my famous articles that's called "Who Cares What Thomas Jefferson Thought About Patents?" But he did later have other comments where he spoke more favorably about patents as well. So although those comments actually are earlier in his career, so at the very start of the patent system, where he talks about the importance of promoting inventions and innovations with the patent system. Although he did write some letters to James Madison during the Constitutional Convention, where he similarly expressed views about patents that he does later in his letter to Isaac McPherson, that these are monopolies and should be viewed very suspiciously. So he was always very ambivalent about patents, and I think it was part and parcel of some aspects of him thinking of himself as kind of a yeoman farmer, and that being very suspicious of the types of commercial activity that followed from inventive activities and the patents that serve as the basis for venture capital and startups and large scale manufacturing that eventually leads to a flourishing society. So it's unfortunate, because he was, a very important person, the author of our Declaration of Independence, one of the most important documents in human history. And so it's just unfortunate that he, used that same rhetorical flourish and criticizing and attacking patents.
According to Kevin Noonan, sorry, I just got to get this out. It's not a question. The term royalty comes from the property rights of the king. You had to pay the king a royalty to mine minerals.
Yeah, I saw that. And also, someone just commented, they said, well, he was maybe suspicious of it, but he didn't vote no to it. Actually, Thomas Jefferson was not at the Constitutional Convention. So this is why he was writing a letter. At that time, he was our ambassador to France. So he was in Paris at the time in 1787. Well, the framers were drafting the Constitution in Philadelphia, and so he was engaged in correspondence with James Madison in particular, extensive correspondence at that time. This is one of the reasons why I think Thomas Jefferson did not have, in this context, did not have an influence on the Constitution, and that was a good thing, because we would not have the patent and copyright clause the way it is, I think, if he did.
Adam, this is Ron. I have a question about the two trains of thoughts relating to patents. The Jefferson view of a monopoly granted by the government, and other thoughts that really think about inventions as property of the inventor, in which the government only secures the exclusive right. The exclusive right is inherent with the inventor to begin with. You can always keep it as a trade secret and therefore keep it exclusive, or turn to the patent bargain to have the government secure his exclusive right. But that thought is not essentially a matter of a grant, but it's more of securing what he's already got. And yet there's a whole school of thought culminating in Justice Thomas concept in oil state, that we're talking about a franchise, a government grant franchise, rather than those two approaches and those two areas have been at odds with each other in academic areas. Do you see any of that moving in our direction, even though oil state is taking a step back?
Oh yeah, that's a question. So what Ron describes are kind of this would have been long-standing views in the United States of patents, a debate that goes back to, as I mentioned, a debate between Jefferson and even Madison on this issue, and running all the way up to the 19th century. There are people who view patents as these monopoly grants from the state, and then people who view them as property rights, justified by the same types of justifications for property rights that you have in other types of property rights, like farms and other manufacturers and things of that sort. And unfortunately, the dominant view today, right now, especially in the U.S. Supreme Court, is that patents are monopoly grants, as represented by, as Ron said, by Justice Thomas's views in oil states and in other decisions. Unfortunately, on the Supreme Court right now, I don't see a change in any of the justices' views. You do have Justice Gorsuch, who does view them properly. And that's a good thing, but he is often standing alone on that matter. Sometimes he's joined by other justices, but they're not consistent. Justice Alito, who joined with Justice Gorsuch in some of his dissents, in some of the patent cases where the dissent was good, Alito joins with the justices on other decisions that are bad. So unfortunately, at the Supreme Court, I don't see a change, and I don't see a change anytime soon. And in fact, I've come around to the view that we should not be supporting taking patent cases to the Supreme Court. They have repeatedly and consistently shown that they don't understand patents. They think that they're monopoly grants. They view them very skeptically and suspiciously. And even when they potentially might think of them in the proper way, chances are they'll still screw up the law. and so we won't get anything good out of this as a general matter, and especially given the number of bad patent decisions we've had out of these Supreme Courts. Supreme Court's re-engaged with patent law in the past 15 years to a degree we haven't seen in over 100 years. They're deciding patent cases now or have been deciding patent cases up until the past year at a rate that we hadn't seen since the early 20th century. And almost all of those decisions were bad. And so if you're a betting person, just on pure numbers, like if they granted cert another patent case, you should bet that they're going to screw it up. They're going to get it wrong. So, I think our source of salvation here is Congress. God help us. Say that Congress is our source of salvation, but Congress has done good things. In the 1952 Patent Act was in part a response to a lot of bad decisions by the U.S. Supreme Court in the 1930s and 40s. And in fact, it got so bad. I love this quote. It got so bad that with the Supreme Court in 1947, Justice not Frankfurter, gosh, I'm blanking on his name. I apologize. It's the end of the day, so I'm a little tired. He wrote a concurring opinion in a case where he says, well, I have to apply the law that the court recently decided, but I have to say the only good patent is one that this court has not yet got its hands on. 1947, and he was writing that in a case in an area that is now covered by Section 103, non-obviousness doctrine, because the court was just going crazy in that area and invalidating patents left and right, and he was bemoaning that fact, and Congress fixed it, and did a good job at fixing it. Section 103 is kind of, from my perspective, the exact type of kind of legislative reform that you should have. It's very straightforward. It's not complicated. It's 2 sentences long. It just lays out the basics, what needs to be done. It overrules the Supreme Court decisions, and it worked very well and successfully for many decades until KSR. And then another bad decision.
So I have a question. So when Congress fixed it in 1952, I have 2 questions actually.
Yeah.
Was there a situation where we didn't have the typical types of huge vested interests who were trying to weaken our patent system at the time, and somehow they didn't have the influence over Congress that they do now? That's my first question. The other question is, do Supreme Court justices all have to read Gorsuch's dissents? In other words, my hope has been if they read his dissent, they're so awesome that maybe it'll change a few minds.
Yeah. Oh, great question. So, so in the first, your first question, so have there been strong vested interests, like I assume you're referring to big tech, that have been anti-patent in U.S. history? The answer is yes, and they played a role in the debates, very much so. So at the end of the 19th century, for instance, the railroads joined together with farmers and formed a political coalition that actually produced bills being introduced in Congress to actually eliminate our patent system. There were bills. These were the anti-Massey bill. Right? They were the Congress has the authority to create a patent system, has the authority to get rid of the patent system. So they were actually proposing to actually just eliminate wholesale the entire patent system. That was, and the railroads were the big tech of the late 19th century. I mean, they were massively powerful, incredibly, financially well off, controlled all of the intercourse in this country. And the reason why they were doing this is because they were your classic vested manufacturing interests, and they were being sued for patent infringement. Because they were large companies and just taking inventions, and the new inventors, individuals, were suing them for patent infringement. And so they not only chose to defend themselves in court, where they wasn't working very well because the patent system wasn't as weak then as it is now. So since they were losing in court, they redirected their efforts by lobbying Congress. And not just lobbying Congress, they would lobby the executive branch, officials in the executive branch. We didn't have the administrative state in the late 19th century that we have now, but there were other cases where executive branch officials took actions against patent owners due to lobbying by people sued for patent infringement. So Alexander Graham Bell, for instance, his patent was attacked by the Department of Justice, not under the antitrust statutes, but just for being an invalid patent, because he was lobbied by the people that Bell was suing for patent infringement at the time. And so these types of things happen. And so in the 1930s and 40s, oil companies very much were playing a large role in attacking the patent system because they were being sued for patent infringement. I mean, so this is the economic pattern, right? So you have kind of the innovators such as yourselves come in, right? Come up with disruptive innovation technologically, commercially, right? Displace the new people or the old existing companies. They themselves eventually become large established companies and they get displaced by the next wave of innovation. This is the cycle of innovation and it's driven our innovation economy. And what is new today is big tech kind of figured out that cycle. They understood that cycle from the get-go. And so they knew that if they were going to survive, they had to short circuit it. So we do have something slightly different now, which is, you know, in the railroads and stuff were lobbying Congress to, you know, get rid of the patent system and stuff. But, you know, but I don't think they were as ideologically dedicated to it as the big tech is, as Google is, Cisco and Intel and these other companies are. And so that is something new. But every era has something new. I mean, that's what makes it, you know, why, you know, history is just can give us kind of insights into things, but there's always some new context that we're having to address.
I got you. So what about Justin having to read Gorsuch's dissent and hopefully learn something?
Yeah, that's a great question. So all the justices do read each other's opinions. So there's a process in the drafting of the opinions, especially when there's dissents, where the justices share their drafts with each other. And in fact, go through multiple versions of the drafts because very oftentimes a dissent will result in a majority opinion being altered because one of the justices that joins the majority opinion reads the dissent and says, well, I kind of agree with that. So I think you need to make some changes to the majority opinion. Or sometimes it'll result in another justice kind of you know, spinning off and writing their own, what we call concurring opinion and things of this sort. So there's actually a very engaged, you know, writing process and intellectual process between the justices in the process of the drafting of the opinions. So all of them have read the dissent, the dissents, the concurrences, early drafts, and this is why they respond to them in the footnotes and actually in the body of the opinions as well. You'll see responses to them, and that's why, because they've seen their earlier versions. But it's very hard to move people off of, you know, the decisions that they have reached. You know, psychologists call it commitment bias, right? Once you've committed to something, especially in writing, especially if you're a judge in an opinion, it's very hard then to say, oh, I was wrong. I need to check myself and correct myself. So, you know, that's the ideal. We hope that people would do that, but I don't see that happening anytime soon. And the number of times that you've had in the U.S. Supreme Court history where you have justices say, a case that I decided 5 years ago or 6 years ago is wrong. I was wrong 6 years ago, and so I'm changing my position. I don't know of that happening ever. It may have happened, but it's not really happened. The time when the Supreme Court reverses itself, it's because they get new justices to join the court over a period of time, who then look back and say, "Well, those other guys were wrong." Right. So that's usually what happens when you get reversals. Yeah.
Makes sense.
Yeah. You had a great question there too about someone asked in the Q&A in the questions about first to file versus first to invent. You know, and this was something that I was very much advocating about on the Hill in the lead up to the American Invents Act, which shifted us to a first to invent system. That the first, because it's my contention that the Constitution requires a first to invent system, because the Constitution refers to the Congress as being authorized to secure to the inventor the exclusive right in their discoveries. And an inventor means the person who's invented something. And in fact, this was something that Congress debated in the first Congress about whether whether they should allow people to get patents simply because they're the first to file, or should they secure patents in the first to invent? Because England has always been a first to file system. Because from England's perspective, patents were not property rights secured to someone to reward them for their productive labors. Patents were simply a tool of economic development policy. Patents were, in fact, originally just a prerogative grant from the Crown. It's where the term patent comes from. Patent is the legal mechanism by which the Crown conferred privileges upon people It was called a letter patent. And it was literally an open letter because it was law. It's called law French. They were influenced by France, and in French, the adjective goes after the noun. So we would call a patent letter. They called it a letter patent. And later, good Americans said, "Oh, letter patent. Well, the noun must be patent, so we're just going to call these patents." so they came to be called patents, even though the patent was the adjective. It just meant open letter. It was an open letter it was an open letter, meant a letter to everyone from the crown, saying so and so has a monopoly to build a bridge, or so and so has a monopoly to run a store or to set up a market. So and so has a monopoly to build a new invention. That's kind of the historical source of our patents, and England really remained wedded to that for a very long time, and still has very many aspects of that. The United States, as I meant, the patents were part of American exceptionalism. They were part of us breaking from England. The Americans said, no, patents are not these privileges that are accorded by the government by mere dint of economic policy or even regulatory whim. This is a property right. This is something that if you, inventor, engage in productive labor, you should be secured in the exclusive right in that labor, in the same way that a farmer is secured in the exclusive right in the labor that produces a farm. And so first to invent is very much part of what made our patent system successful as a property right system, as opposed to a regulatory system. And it's not a coincidence that the shift to first, that in creating the PTAB, we also shifted to a first to file system, because this is the shift to this kind of administrative regulatory perspective of patents now, that these are not property rights secured to Randy and Paul and Josh and Ron and everyone listening to this. These are just kind of regulatory entitlements that the government grants out, like carbon carbon offsets and things. And what the government giveth, the government can taketh away, because it's just an entitlement, it's just a grant. And so we need to look at well, what are the reasons why, policy reasons why we have this? This isn't about rights. This is about economic policy or regulatory policy. And that's kind of shows you the importance of kind of these foundational issues where you might not think first to invent versus first to file, what's the big deal? It seems to be a minor kind of technical derivative issue. It actually goes to the very foundations of what it means to have a patent system. Is it going to be a property right system, or is it going to be an economic regulatory system? Because these were the two perspectives on patents for a very long time. England and the rest of the world mostly viewed them as monopoly grants that furthered economic regulatory grants, which is why they did first to file, because you didn't have to be the inventor.
Yeah. I actually have one here from one of our new members, Molly Metz.
Mm-hmm.
I can find it here. Do you know Molly?
No, I don't, but I was just saying that there's a question. So
She's another example of an inventor who's been destroyed by the PTAB, had her valuable patent invalidated. So she said, "Hi, Adam. It seems clear how you describe our patent history and what it means to our country. Why do you think Congress passed the AIA bill? Do you think if they heard you speak, they would understand the impact the PTAB has had on inventors? It seems so clear. Who has rebuttal to you, and what do they say to you? What inventor patent actually thrives with the AIA PTAB?"
Yeah. Well, first and foremost, Molly, thank you for the question, and I'm really sorry that you have been put through the travails of the PTAB. And I wish that I had been able to fight, more effectively and more strongly on behalf of you and Josh and others who've been harmed by that institution. And well, they have heard me. I've testified before Congress now 5 times, and one of them explicitly on the PTAB. And I've done what are called staffer briefings, and I write what we call in Washington D.C. white papers, which are these, lengthy essays or short articles that are distributed and available on the web, not in academic journals, for and you try to write them in ways that they're accessible to intelligent people who aren't lawyers and understand the importance of these issues. It's one of the reasons why I do what I do, because I care about these issues. It's important to me, and I want to get these ideas out there. But unfortunately, there are people who just disagree with me, and also there are, as Randy intimated earlier, there are a lot of very vested interests who view patents as a blockade to their short-term success of their business models, or simply they just want to steal. And they have a lot of money, and they've spent a lot of money. And millions and millions of dollars have been spent lobbying Congress and engaging in what we refer to in the law strategic litigation. So, eBay and all these cases are cases that are deliberately litigated to reach the result that they do. And of course, lobbying officials, whether at the PTAB or even the FTC and DOJ, to attack patents. And it's been this kind of perfect storm. And because they don't just use this money for lobbying, they've used the money to fund advocacy groups. So you have the Electronic Frontier Foundation, you have the Center for Democracy and Technology, you have Public Knowledge. These are all groups that are basically massively funded by Google and Facebook and Apple and other companies now. And they then publish their own white papers and file their own amicus briefs and cases, and they testify before Congress as well that, patents are destroyers of innovation, they're blockades innovation, the patent system's broken, they're attacks on innovation. They propagate all of these horrendous untruths. And false rhetoric. I mean, we all know the term patent troll. The reason why patent troll became such a dominant narrative was in part because it was deliberately pushed into the policy debates and in the broader kind of mainstream media through the PR efforts and lobbying efforts of big tech and their supporters in academia and the advocacy groups that they funded, to the point now where people on the street know what a patent troll is, which is just, to this day, is just shocking to me. People who probably never really heard of a patent before, they all know what a patent troll is. And that's just become the conventional wisdom, right? For instance, every time you try to advocate for reform and getting rid of the PTAB, or even minorly limiting the PTAB in some minor way, like what the Stronger Patent Act did by just putting on some posing some minimal due process requirements and things of that sort. The advocates from Google and Apple and Intel all jump up and say patent trolls, this is going to unleash patent trolls. And that just shuts down the conversation. Everyone says, "Oh my God, you're right. We can't have patent trolls." And there's no these in the junk science studies that were paid for and pushed out into the policy debates by big tech to try to show how patent trolls are destroying the economy. They've been disproven. I can't tell you how many times over in academic journals and in publications, and those are just ignored because the narrative has just become established now that patents are tools of oppression and hamper innovation, and our patent system is broken, and that if only patents went away, then Google, which spends more money on probably coffee for their employees than the entire budget of my law school many times over, would then all of a sudden becoming a great innovator. It's just like, no, it's just, it's hard because, and this isn't unique to this term, because this era has always been truth that, unfortunately, falsehoods and rhetoric dominate as opposed to truth and truth and justice. And this is why you want to build institutions that can withstand those attacks. And for a very long time, our institutions have. And unfortunately, starting in the 21st century, they eventually started to break down. In part because of big tech, but also in part just because we got lucky. The patent system was largely insulated from the destructive influences of the broader administrative state for much of the 20th century. And it was only, starting in the 1990s, actually, is when the administrative state started to make inroads into the patent system. And the AIA really represents kind of the culmination of that.
Yeah, but I guess to Molly, I would say, certainly, the bad guys have done an awful lot of lobbying and an awful lot of presenting of false data, and we're fighting to turn that around. And big tech is known. Look, Adam, you'll appreciate this. A young staffer said, I don't know, a month or two ago in DC, young staffer said, you know, one thing that's going to help you guys is it's become cool to be against big tech.
Yeah. Yeah. Yeah, the black eyes that they've gotten has been very good. You know, because it used to be that Google could walk into any Congress person's office and say, "We're Google and we think X," and they'd be like, "Okay, you're right."
Yeah.
Hands down. That doesn't happen anymore, and that's a good thing. You know, but also, and I don't want to be too bleak, because I don't mean to be bleak, because actually there have been significant changes in the past several years, large part because of efforts by U.S. Inventor, in large part and efforts of other organizations like Innovation Alliance, but individual efforts like people like Josh and Randy and Paul doing the hard work of going to congressional offices and talking with people, and that's and me writing my op-eds and trying to do these things, and trying to write these things. I've had some staffers starting to come to me saying, hey, I think maybe there might be something to this. So, we are making progress, and so the important thing is to keep fighting the good fight. The important thing is, for you guys to keep doing what you do best, which is innovate and invent and, show what it means when inventors are protected in their inventions and innovations, and to show the destructive influences, unfortunately, what happens when you're attacked by the very institutions that are supposed to protect you. And people like me and Josh and others also can continue to advocate on and draw the broader connections and push for good legislation and good court decisions and push back against bad regulations. Like we won a really important fight just this past year when we convinced the Department of Justice not to issue this new horrendous antitrust policy statement on patent licensing. That it's in the context of what are called standardized technologies. The patents on 5G and Wi-Fi and things of the sort. But it wasn't limited just to that. It was part and parcel of the broader attacks on patent licensing and patents more generally. And they were going to issue a new policy statement that was absolutely horrible. And regulatory agencies, before they issue adopt a new policy, they have to do what's called a notice of comment. So they have to solicit comments from people. And I organized and co-authored a comment filed on behalf of 27 law professors and economists and former government officials, and Andre Yanku and David Kapos and others submitted, a comment on behalf of former directors of the USPTO and former officials of the Department of Justice, bipartisan too. I also participated in comments filed by the Hudson Institute and other comments filed by other organizations, and they actually got a significant number of negative comments. And because of the number of negative comments they received, they chose not to adopt the policy. And that was a major win for innovators and inventions. And so we are starting to achieve some successes, and through those, we're changing slowly the narrative, we're changing the attitudes and challenging the falsehoods, and hopefully this will result eventually in something like Thomas Massey's bill being enacted. That would be awesome.
Yeah. Well, Adam, I don't know if I should keep you any longer. You've been here over an hour, and we greatly appreciate you talking to us and giving us your thoughts, and look forward to working with you in the future to help fix this system that our country needs us to fix it. So we're gonna make it happen.
Well, thank you, Randy, and it's been a pleasure to know you and Paul and Ron and Josh and Joel. I know of you. I don't think we've met actually in person. Perhaps maybe briefly at one point.
We're on the IP professors listserv.
Oh yes.
I'd also suggest that invite some of these creative people in this organization and others to speak to your law students, the future judges and litigators, so that they can understand, if they don't create themselves, and many of our founding fathers were creators, they were authors, they were inventors. Think of the guy who got electrocuted flying the kite, for one.
You got lucky.
So they can really understand what it means to someone like a Molly or to someone like a Josh to be creative and make that your life's work. And when that's taken away, how destructive a force that is. And I've found with my students that, if you give them a case that they can relate to,
Mhm.
that it so changes the attitude. I'm certain that many members of this organization would love the chance to tell their story
Yeah.
to some of the future lawyers, so that they can understand better what it's
Yeah.
like.
I agree wholeheartedly. In fact, that was when I co-founded an intellectual property center about 10 years ago. I stepped away from it several years ago, and it's since changed. But one of our founding principles was to do exactly what you said. And in fact, that's one of the reasons why how I got to know Josh so well, is because we were inviting him to our conferences and to our roundtables that we were having with other academics. And at our conferences, we had one of our first conferences, we had Dean Kamen as one of our keynote speakers. At another conference, we had Erwin Jacobs, the creator of CDMA technology and founder of Qualcomm, talk about his inventive process in the 1980s when coming up with that, this technology. I agree 100%. People need to hear from the actual innovators and inventors and creators, what it means for them to create, the importance of being protected in their creations and the property rights and the way that we're protecting our homes and our cars and our businesses, and how destructive it is, exactly the right word, when their rights are taken away and their creations are stolen from them. Yeah,
Yeah.
really. It's invaluable. I would, and I'm not organizing conferences anymore because I'm no longer running that IP center. But if I do get back into organizing conferences that way, I will certainly be, inviting Paul and Josh and all the others back again. Yeah. And Molly and others, hopefully.
Yep. Great. Well, thanks again, Adam. Really appreciate it. We're gonna talk a little bit further. Paul, stay on for sure. We want to talk about the comments on the small claims court. But Adam, you're welcome to hold on if you want, or if you want to leave now, you can. But thank you so much.
Yeah, I'll step away now. I have family commitments, but people should feel free to reach out to me too. I'm actually a member of the consultative group. I was invited to be a member of the consultative group for the patent small claims court process, and I accepted that in part because I wanted to make sure that it stays on the rails, so to speak. It doesn't go crazy. It doesn't get captured by anti-patent interests, and because they have recently created a small claims court for copyrights, and that's actually a really good court, and it's actually already being used by creators to defend their rights in really good ways. It just started receiving petitions in June, and I think if they do this right, it can be a source of addressing some of the complaints about the cost of litigation that Joel and others raised. But we're gonna have to be very careful about this, and this is one of the reasons why I agreed to be on the consultative group, because I just want to make sure that this that respects the constitutional requirements and legal requirements, and also respects the rights of innovators.
All right.
Adam, a quick question on this, if I may.
Sure.
On small claims, typically in regular litigation is typically not on matters of equity, but only on awards and legal remedies. Is that the same intent in the small claims patent case, not to enter into issues of equitable relief?
Yeah, so that was one of the questions that kind of came up in our initial meeting. If you read the notes that they were talking about is, well, what's the scope of remedy that can be afforded through this process. So for instance, in the copyright small claims court, you can only get damages. You can't ask for an injunction. And that was I think a deliberate choice, in part to respect some of the constitutional requirements about adjudicating claims through Article 3 courts, and so it'll be interesting to kind of see how they kind of thread that needle, because I think a lot of patent owners are more interested in injunctions than they are actually receiving damages.
Yeah, well, we actually, and I should let Paul jump in here, but we've kind of got a different take on it. Rather than a small claims, we'd like to see it be a small entity court.
Mm-hmm.
Paul, jump in here and give.
That was actually something. So that was a big topic of discussion at we had our very first meeting at the end of July. And that was the discussion. It's kind of like, well, is it about small claims, or is this about allowing access to people who are undercapitalized, so startups, individual inventors, and others who don't typically have access to federal court given the expense, because you end up with a very different type of institutional structure depending upon what you think the problem is. Is the problem that the claims for damages are too small relative to the cost of litigation, or is the problem that people are priced out of the court system because they're undercapitalized as individuals? And I think you guys as US Inventor can really weigh in on this, because you are the people who you are the ideal group of people that they're thinking about as to being the people who would be the beneficiaries of this institution. And so you can have actually, I think, a really significant role and a proper role in influencing their decision making as to what should be the focus and what should be the purpose of what this potential new court type system is focused on.
We submitted our comments, which are not small claims. We want small entity. And that small entity can be either side, the patent holder or the company that's being sued. It solves their conundrum of, or the engine statements about how little companies are always getting sued. But then asking to cut out the damages stuff, to award injunctive relief, to limit motions, to establish some rules of thumb on damages. For patents that are either not the small entity is not asking for an injunction on, or they're expired or not really able to get an injunction.
Mm-hmm.
But effectively, the small entity and reducing the cost of the small entity.
Yeah, I think that I think that's largely right. I mean, I think of when I think of small claims courts, I think of it, it's typically individuals who, have had, not large corporations. Large corporations are not users of small claims courts in states. They, it's a family, it's an individual who has who needs restitution for a harm that they've suffered, and they don't have a lot of money and can't afford suing in regular court to obtain that, even in a state trial court. And I think, another thing that you guys can really do to help is, help influence and prevent this to become a PTAB by emphasizing it has to have due process. And actually also, I think a really key, one of the key features of the Copyright Claims Board, as it's called, the Small Claims Court for Copyright, is that it's voluntary. Because this was the way that they got around some of the legitimate Seventh Amendment concern. Which is a legitimate concern and should be respected.
We asked for federal rules of civil procedure, rules for small entities, such that and not consolidated into one court. You see what happens with the federal circuit now. We've got a whole bunch of independent judges, and it's a crapshoot on whether you're going to get treated fairly or not. That's a consolidation of power, and that consolidation of power is dangerous. If you have any court like the PTAB with a consolidation of power, you end up with problems too. So you ought to be able to go to whatever Article 3 judge you want to go to, the one in your local area, and ask for small entity rules from the federal rules of civil procedure. And if you qualify as a small entity, you ought to be able to get them. And then that ends, it's still an Article 3 court. It gets around most of the constitutional issues. And you can reduce costs for everybody that way, and that was what we proposed.
Excellent, yeah.
And they're still taking comments until Friday now. They've extended it. So one of the things I want to say to all our members, we're going to be getting out another email pushing for you guys to give your comments, and this one will be a little more with some instructions, with maybe a little bit of more of a summary of kind of what we're proposing, but. As Adam has said, we can totally move the needle on this and make it turn out right, and that's what we have to do.
Yeah, I mean, and I lead with, I'm going to be, I'm the person that you are thinking of as the user of this institution. I am the person that exactly needs this institution that you're thinking about creating. So let me tell you what you need to do in order to get me justice. Yeah. And, you know, in that, and more broadly within your organization, you know, Congress is responsive. Yeah, there's a lot of money spent by Google and others creating narratives like patent troll and patent holdup and all these other horrible terms, patent thicket. Yeah, but and you know, and there's a lot of falsehoods. But you know, it's also true that that the same technologies, you know, that have made those companies very powerful and wealthy have also empowered you as individuals. So, I mean, individuals have the ability to organize through U.S. Inventor, and have the ability to speak to and access congresspersons and other government officials and even agency officials in ways that they never had before. And I think, you know, that really that's significant. That's huge. And, you know, it's cool to see, you know, we've had this democratizing aspect of the internet and of internet type technologies and communication technologies that have made possible your organizational efforts, right? And connecting, you know, innovators throughout the country who, if 20 years ago, let alone 15 years ago, right? US Inventor would not think of the cost and difficulty would have been to run US Inventor 20 years ago. You would have been sending out mailings to people through the mail, your post office and stuff, you know, or maybe email, but you wouldn't have mass email programs. It would have been taken hours and hours and hours to send individual emails to people and things of that sort. And you couldn't send attachments, and you couldn't have auto responses, and you couldn't submit things via websites and stuff. So it's, you know, take advantage of that, and fight the good fight. I'm always, you know, when I talk with, you know, friends and colleagues, you know, it's always say, keep fighting the good fight, because, you know, you even if it looks like it's, you know, it's you're going to lose, right? You want to, you first of all, you never want to go down, you never want to lose thinking, you know, I didn't fight against it. But B, you might lose on something today, but the fight that you're fighting today means that you'll win the next day. You know, so, and, you know, and I'll tell you, you know, there were times, you know, back in 2014 when we were fighting over the Innovation Act, Josh and Ron and Randy and Paul. I don't know if Joel, you may have been involved in that, but that was like trench warfare.
Oh yeah.
DC.
Oh yeah.
Yeah. And we won. And
Yeah.
it was shocking that we won, right? It was shocking that we stopped that bill. And by the way, that was the very first time in U.S. history that a bill that had passed the House by something like, well, they got over 300 votes.
It was 300. It was 325 to 91.
Yeah, I mean, it was a massive, overwhelming majority vote. That every other bill that had that many votes in the House always got enacted into law. Always.
Right.
And
Because all these guys, all these lawmakers would have to change their vote, and then they'd be called flip-floppers. Right?
Yeah. So when that House vote happened on the Innovation Act, everyone was like, oh, okay, it's over. It's going to become the law. And we didn't give up fighting it, right? We kept hammering the people on the misinformation and on the falsehoods and on the rhetoric, and we won.
Well, you know, one thing you may not know. So Paul and I were fighting like crazy, visiting almost every single representative. And as I was still fighting, and we were in the House, we decided we were going to stop in the House. But before it was all over, I was still in the House, and Paul was in Iowa chasing Grassley down at all of his town halls.
Yeah, I remember that. Yeah.
You know about that? Okay.
Paul, you were his shadow. You were not letting Grassley get away. And by the way, and I'm saying we generically, but I really mean you guys, because the reality is ultimately that bill went down because individual inventors and also I think combined with other organizations like universities really stepped up and really made the case to senators and others how destructive that bill was going to be.
Right.
And that's and as a result, that the building get enacted into law. And so, it can work, and it continue to do what you've been doing. That's a good thing.
Well, thank you so much. And to all our members listening, so be on the lookout. We're going to send another email about the comments for the small claims court. And as Adam said, we can move the needle on this. Just take a look at it, put it into your own words and put your comments in. It will help move us forward and get the right result. This is what we've always had to do, and we have a moment here where we can make a real difference. So definitely keep a lookout for that tomorrow. And thank you, Adam. Thank you so much. We'll definitely keep in touch.
All right. Looking forward to it. Looking forward to seeing you all again sometime in person.
Right, thanks.
All right.
See ya.
Bye-bye all.